Hello and good morning, good afternoon, wherever you are logging in from. My name is David Vandenberg. I'm the chair of the subcommittee for transaction integrity for NAFA. NAFA, if you don't know, is the National Air Finance Association, and the priorities of the organization are providing networking events and education for our members, who are comprised of lenders and service providers in the business aviation financing space. NAFA has several committees, transaction integrity being one, regulatory compliance. We have a light aircraft roundtable and a NAFA charitable organization to promote further education in studies in business aviation. This event came about because of an idea that Jeff Towers had, and we're fortunate to have TVPX sponsor today's event, which is focused on due diligence 101, and is a very important topic. It came about because we have networking events for people at the banks and the service providers in our industry who are leaders in the companies, but we all recognize that they often defer to the expertise of people in their organizations. And so the invitation went out to our member companies to invite people who are doing due diligence on a day-to-day basis to participate, share in learning, and hopefully provide some future collaboration. Hopefully this is the first of what could become several events in a series dedicated to due diligence and transaction integrity. So without further ado, I'd like to introduce Jeff Towers, the Vice President General Counsel of TVPX. Thank you very much, Jeff, for your idea and for taking the moderating and hosting role for the event. Thank you.
Thank you, David, and welcome everybody to the first, as David explained, is what we hope to be a series of due diligence related presentations. Our goal is really to provide a source of continuing education, hopefully one of several different sources of continuing education for people who are engaged in due diligence in our industry and business aviation. And as David also mentioned, we want to try real hard to make this accessible to everybody in a company, both those who might be regular attendees of conferences and things like that, and those in a company that typically wouldn't be attending an NBAA event or other industry event. So we're very fortunate that NAFA has agreed to not only host this webinar, but also to make the webinar available on its website, a recorded version, so that other people in your company, let's say you hire somebody new or whatever the case may be, who might be able to benefit from some of the information that's provided here, would be able to get access to that webinar through the NAFA website. And so we encourage everybody to pass that word along within your company or within your network of people that you work with. And in that respect, we really do have to give a huge thank you to NAFA for doing all of this. It's just great to have the support of an industry organization, an important industry organization like NAFA in this initiative. I'd also like to introduce our speakers. Laura Martino is the Assistant General Counsel at Global Jet Capital in Connecticut. She provides legal guidance for her company on issues like sanctions, anti-bribery, anti-money laundering, and data privacy. David Hernandez is a shareholder at Federal Price in Washington, D.C. He advises clients on aircraft transactional matters and has a focus on regulatory matters involving aircraft. So between these two speakers, we have people who live and breathe the subjects that we're going to be talking about today. And in David's case, his background as a prosecutor might lead him to remind us of some of the things that might go wrong if people don't pay attention to some of the issues that are important for us for doing due diligence. So I'd like to hand things over to Laura for a start.
Thanks so much for the warm introduction, Jeff. And it's so great to be here with my esteemed colleagues, David and Jeff, and all of you. Thank you for making the time to attend today. It's important to know who our regulators are. I don't know if everyone can see the slides. We can have them handy. And so drilling down, if you take a look at the agencies here on this slide, these are the agencies that we're hoping to talk to you all about. It's important to know not just who your functional regulator is in the space relevant to your industry segment, but also what these regulators do. So we're going to start, I'm going to kick it off. I'm going to talk you through the Office of Foreign Assets Control, FinCEN, the Financial Crimes Enforcement Network, the SEC and the DOJ. And then I'm going to turn it over to David, and he's going to take you through other administrative agencies that impact aviation, such as the FAA, the Bureau of Industry and Security within the U.S. Department of Commerce, Customs and Border Protection, as well as the agency that promulgates our ITAR export control regulations, the DDTC. So next slide. Please, we will kick it off by talking about OFAC, the Office of Foreign Assets Control. OFAC sits within the U.S. Department of Treasury, and it's charged with enforcing our economic sanctions against individuals and countries that undermine our foreign policy or pose a risk to our national security. These sanctions are looking to really restrict our dealings with adversaries that are involved in activities like terrorism financing, drug trafficking, human trafficking, and other illicit acts. This agency, OFAC, the Office of Foreign Assets Control, like all agencies, are part of the executive branch, but they're really promulgating regulations that touch on national security. So they get their power from various pieces of legislation, such as Trading with the Enemies Act, TWIA. This is the legislative framework for all of our Cuban sanctions, as well as the International Emergency Economic Powers Act. These are two acts of Congress that delegate this authority to the executive branch, because these agencies, such as OFAC, within Treasury, is part of the executive branch. So that's the sort of legal authority, if you will, behind OFAC. But let's talk a little bit about what OFAC does and what are sanctions. Sanctions, to put it briefly, are restrictions on imports from, exports to, or financial dealings with countries or individuals that pose a risk to our national security. If we can go back a slide, I'd like to explain that sanctions actually are sort of two-pronged. You have what's called your country sanctions. These are countries or jurisdictions that are targeted as our adversaries. And presently, you can see on the screen, those countries include Cuba, Iran, North Korea, Syria, and Crimea. Russia's not up there because those sanctions, even though we've seen so much robust activity in terms of promulgating sanctions against Russia, they're not considered comprehensive. I know David's going to talk a little bit as well on the Russia sanctions. But what are the requirements? What is imposed on you as a company in this space? Sanctions prohibit U.S. persons, that includes companies, individuals, from importing, from exporting to, or engaging in any kind of financial dealings with these countries, or with what's called specially designated nationals. This is considered our list-based sanctions, and these are non-state actors. So we're talking about individuals, groups of individuals like terrorist organizations, drug cartels, right? More and more, and we're going to talk about it in our next slide, we see that our adversaries are not really defined by a country anymore, right? They transcend geographical boundaries. And so these are individuals that are scattered all over the world that OFAC poses restrictions on. So in terms of list-based sanctions, in addition to these comprehensive country sanctions, you have certain individuals that appear on a designated SDN list, specially designated nationals. And it's important to know when you're engaging in a transaction whether or not your counterparty appears on this list. If they do appear on this list, or if these entities are in any of those countries that are designated as sanctions, sanctioned countries, you're not able to do any kind of business with them. So that's sort of the framework in a nutshell. But these what an interesting trend that we're seeing is that more and more these individuals are harder to identify, particularly when you're dealing with entities that are designated as SDNs that can hide their identity through numerous shell structures. So we're going to talk about that in a second. I want to just point out that Russia's not on the list because really the sanctions that are imposed against Russia, and I think everyone at this point is privy to it because of the 2022 invasion of Ukraine, really led to some pretty robust sanctions, but they're not, it's not a complete prohibition against the country. But this really started back in 2014. We saw the first imposition of Russian sanctions due to the annexation, what led to an invasion in Crimea and its eventual annexation from the country. But we also saw Russia being targeted by OFAC with economic sanctions for its 2020 election meddling in U.S. elections, right, undermining our policy objectives. And that resulted in the designation of 10 officials from the Kremlin who were close to Mr. Putin. And those individuals appeared on the SDN list. But we also saw cyber threats coming out of Russia. I think the most popular is the SolarWinds hack, which resulted in several Russian cybersecurity companies or cyber companies being designated on the SDN list. So you kind of piece together all these different executive orders and all these different regulations that designate Russian entities on the SDN list, and it starts to make sense, almost in a way that you can start to predict which counterparties that you're looking into to do business with may appear on an SDN list over time. A practical tip that I'd like to share with all of you is to read the executive orders, to really understand the purpose behind these economic sanctions, because it really does help you when you're doing your due diligence on your KYC on your customers or your counterparties to understand whether or not there will be a risk in the future of any of these counterparties becoming sanctioned. So that's sort of my piece there. Okay, next slide. So let's talk a little bit about some key developments with respect to economic sanctions and OFAC regulations. Like I said, we start to see that these sanctions have increased in complexity with enforcement actions against companies that violate these sanctions regimes at record highs. So we're seeing more in terms of like more significant penalties. OFAC indeed raised penalty amounts in recent years, and we're seeing more enforcement actions. So the sheer volume of companies that are violating or are being penalized for violating these regulations has steepened. I think the other complexity here with respect to sanctions law is that the sanction programs by the U.S. government is increasingly covering non-listed parties outside of sanctioned countries, right? And so the targets can be characterized as non-state actors and adversaries that transcend geographical boundaries. Why did I say this twice? Because I'd like to draw emphasis on the fact that it is sometimes difficult to comply. And the other piece to this is if you violate any of these sanctions regulations, it results in a strict liability offense, which means that regulators don't have to prove that you tried to circumvent sanctions. Rather, all they have to prove is that you did it. You did business with someone on an SDN list, right? And now you're in trouble. So, it is something important to incorporate into your due diligence policies and procedures. So a couple of key concepts that evolved in recent years is something I'd like to walk you through. So one such thing that evolved is this notion of sanctions evaders, okay? It is not enough to know who our SDN players are, like who are the bad actors that we're going to avoid, in addition to checking against these lists. And we're going to really walk you through that later on in our discussion. It's important to know who your customers are and whether or not they are engaging with SDNs, okay? Because right now, the US government, the Office of Foreign Assets Control, is identifying what's called sanctions evaders, which could be companies in other countries like China or in the European Union who are not sanctioned. They are our friends. We do business with these companies all the time. If they're going to start to ignore US sanctions, the US government is now starting to penalize those companies by placing them on an SDN list. So just to kind of repeat this, if you're dealing with, like, say, a European company that is not on an SDN list, that is not in a restricted jurisdiction like Syria or Iran, but they're doing business with, say, an Iranian company, that company that you're doing business with might end up being on an SDN list. So be aware of sanctions evaders, okay? Be aware of companies that are not in the US, that are not complying with US sanctions, because these sanctions are beginning to have an extraterritorial reach. And so the next concept is this notion of the imposition of secondary sanctions. And that's where you see, a real clampdown on companies. And look, I'm not picking on targeted jurisdictions, but we're seeing PRC-based companies that are starting to appear on the SDN list, not because they're undermining, not because they're considered to be adversaries of ours, but because they are trading with the perceived enemy or our adversary. So keep that in mind. Other trends that we're seeing, in addition to like PRC companies, Chinese companies that are, say, for example, sourcing out of North Korea in violation of our US sanctions, we're seeing them start to appear on the SDN list. But we're also seeing, these ship-to-ship transfers. And indeed, OFAC has published numerous guidance on this. I think one in 2019, where they looked at and started to track illicit petroleum imports and coal exports. So in addition to sourcing labor from North Korea, you're seeing illicit oil sales involving Iran, North Korea, and coal. So keep that in mind. And then I would say that the other complexity is that these sanctions are dynamic. Okay, they're changing all the time. So a good case in point are the Iranian sanctions. You saw an Iranian sanctions lift under the Obama administration. And that was because we entered in a nuclear deal with Iran. And then that was after the lift under the Trump administration, those sanctions got reimposed against Iran. So the snapback of sanctions could be troubling from a commercial perspective. So it is something to keep in mind, but it also poses very unique challenges under conflict of law. So it is raising conflict of law issues because you have certain jurisdictions that want to continue to do business with Iran. Iran's just a good example. So take, for example, European Union countries who may not be sanctioning Iran at this time. They want to continue to do business with Iran. It does not violate European law or the laws of their member states. And while that might be good and fine, the US will then, or has indeed, punished such companies because it violated our sanctions regime against Iran. The interesting part about this, and I don't want to get too much in the weeds, but this actually happened with a company, Telekom Deutschland, where they terminated a services contract with an Iranian bank, Bank Melli, right? And Bank Melli, the German entity, sued Telekom for violating the European blocking statute, which basically states that that European countries should not abide by sanctions law of other countries. They should really stick with EU sanctions policy. And the European Court of Justice actually opined in that case and ruled that the European law trumps German law, and that they agreed with Bank Melli, and they compelled the counterparties, i.e. Telekom Deutschland, to proceed with their services contract. So some companies that are countries and companies within those countries, so European countries and companies in those jurisdictions are often caught in the crosswinds of these conflict of law issues. So those are tough to navigate. but it is something to keep in mind that I guess the practice tip, if I were to boil it down for everyone here today, is to read those executive orders, be aware of what is happening, and know your sanctions programs. But then the flip side to that is know your counterparties, know your customers, because even though you think your customers have nothing to do with Iran, have nothing to do with sanctioned jurisdictions, because they're not based there, they might actually be trading in those jurisdictions, and that could pose a problem down the road. And one thing that you can do is maybe take a look at your commercial contract provisions, and maybe for some sensitive jurisdictions like your deals with China, you might want to include a provision that states that doing business with a sanctioned or blacklisted party could result in a default, right? We want to have an out in the event that you do have a customer that isn't following U.S. sanctions law. So something to discuss with your legal departments. So read your executive orders and understand some of the complexities of this. Another good practice tip is to take a look at some of the government guidance that's been issued. The Office of Foreign Assets Control is very active in collecting data from enforcement actions and making that information available in the form of advisories. So if you go to the OFAC website, you can take a look to see where the clampdown is taking place. And that's where you find out about some of the stuff we're talking about today. Another good practice tip is to take a look at the OFAC compliance program guidance that was published recently. It really sets forth some key components of an effective compliance program. That includes, commitment by management that has to do with corporate culture and tone at the top. Risk management is another key component, and that really states that companies should be looking at the geopolitical context of these sanctions to identify where the risk is, right? No regulator wants you to spend too much time on something of very little risk and then not enough time on issues that seem like big deals. So conduct your risk assessments and take a look at your customer profile and try to understand what industries might be impacted by economic sanctions, as well as which jurisdictions are the trickiest. And then another element of the OFAC compliance program guidance includes internal controls. So again, making sure that you've got onboarding customer policies and procedures that break down KYC, points of escalation to management. And we're going to talk about that. We're going to talk about effective compliance programs and what some of those might look like. The OFAC compliance program guidance also talks about testing and auditing. You want a defensible program. So at the end of the day, you want to be able to say that you've looked at your own internal controls, you've looked at deficiencies in those controls, and you've corrected and mitigated that, because regulators do want to see ongoing tweaks and ongoing learning and perfecting our craft, if you will. And then the final point on the OFAC compliance program guidance is training. You have to have ongoing training. Like what we're doing today, is something that you want to do in all areas of compliance that address your company's risks. So you want to make sure that the training is ongoing every year. So that's all I have on key developments. I'm not sure if we have any questions on that, but I'm going to then turn to the next slide. So FinCEN, the Financial Crimes Enforcement Network, is a bureau within the U.S. Department of Treasury, and it's responsible for combating and preventing money laundering, terrorist financing, and other financial crimes. So their mandate is to really maintain the integrity of the U.S. financial system by precluding ill-gotten gains from entering into our stream of commerce. What is money laundering? I think everyone knows more or less what this is at a very high level. It's really an attempt to hide or conceal sources or proceeds of illegal conduct by integrating these ill-gotten gains and making them look legitimate, cleansing, cleaning money. And so there's different regulatory schemes that combat this issue. One is the Bank Secrecy Act. Look, we're not going to go into this in detail because it applies narrowly to covered financial institutions, including banks. But this is sort of your baseline. And then over time, we saw the enactment of the Money Laundering Control Act in the late 80s. This is probably the most robust of all of the frameworks in terms of criminalizing money laundering. And it applies broadly to everyone, right? Whereas the Bank Secrecy Act regulations, some of those apply very narrowly to covered financial institutions such as banks. The Money Laundering Control Act is a law that everyone here should pay attention to. And it basically prohibits persons and companies from accepting proceeds from ill-gotten gains in their transactions. So we cannot accept ill-gotten gains or what's perceived to be tainted revenue from illegal conduct. And so within that, and we're not going to go into detail about that, but just know that there are specified enumerated categories of ill-gotten gains. And those are things like drug trafficking, right? We can't accept proceeds from that. But other categories include sanctions violations, right? So if you are violating economic sanctions, right, OFAC regulations, you might also run the risk of violating anti-money laundering laws and regulations. So keep the Money Laundering Control Act in the back of your minds when you're looking at customers. And then the more recent, and we're going to talk about a group of amendments that occurred very recently, but in 2021, following September 11th, the U.S. Congress enacted the U.S. Patriot Act. And I think it sets forth the most robust set of regulations for covered financial institutions in terms of how to go about due diligence. And we're going to talk about how we can take those elements and incorporate it into a compliance program so that we're covering the basis. But it sets forth a customer identification program or a SIP program. And it requires companies, covered financial institutions, to identify and verify their customers, to identify politically exposed persons or PEPs, to verify source of wealth, and to conduct enhanced due diligence if the risk is warranted, if it's a high risk proposition. So that's the customer identification program in a nutshell. I understand it might not apply to everyone here, but I really think it's a great framework and potentially a best practice to follow, even if you're not forced to follow it, because you still have to comply with the Money Laundering Control Act, right, which generally prohibits ill-gotten gains. So if how do you go about achieving compliance with the Money Laundering Control Act, which applies broadly to everyone? I would say take a look at the SIP program, Customer Identification Program, and do those things I just mentioned, right? Identify and verify your customers, identify politically exposed persons, verify source of wealth, and go ahead and conduct enhanced due diligence, if it's warranted in high risk cases. And I would argue that if you can show that you're not treating all your customers alike and that you're giving a little bit more attention to customers that need it because they're perceived more high risk. What do I mean by that? Either their industry, right, oil and gas, or their jurisdiction is tricky. Then go ahead and do the more enhanced due diligence. And we're going to talk about that in just a moment. But I wanted to just make you aware of this regulator and these groups of regulations. We're going to flip to the next slide and talk about key developments in money laundering. So I think it's important to know that, and I mentioned this earlier, that illicit actors often use corporate structures like shells or front companies to hide their own identities. Because maybe they're on, a government hit list, and to launder their ill-gotten gains through the U.S. financial system. And it's problematic because it undermines our national security, but it also arguably creates an uneven playing field, right? Because it makes it hard for good companies in the U.S. to trace the ownership in offshore jurisdictions. And so because of this, very recently, the various international frameworks have pointed to deficiencies in various governments to identify ultimate beneficial owners. It's not just the US. Many other jurisdictions have these kinds of deficiencies. So the US government responded, but initially in 2016 by rolling out a customer due diligence ultimate beneficial ownership rule. And it poses beneficial owner reporting requirements on certain covered financial companies. And it requires that certain financial companies collect ultimate beneficial ownership information from their customers when they're opening an account. So this is going to be the kind of thing that banks are required to do and other similar financial institutions. When they're onboarding a customer, it requires that you identify who owns your customer. And ultimate beneficial ownership is not a new concept. Indeed, OFAC has said, and I failed to mention this when we were talking about OFAC, but OFAC said, look, it's not enough to identify your counterparty as blacklisted or restricted, but you must also understand if any of their ultimate beneficial owners are blacklisted or restricted. So fast forward to these new UBO rules, it's a different regulator saying the same thing. You need to understand who owns your company. So there's the customer due diligence rule for financial institutions, and that has to do with them identifying beneficial owners of their customers. But then very recently, Congress enacted the Corporate Transparency Act. And what that requires is for a reporting company to identify their own ultimate beneficial owners, not their customers, their own, and not just identify it and keep it on record as you're required to do if you're a bank when you're opening a customer account, but under the Corporate Transparency Act, the UBO rule, the beneficial ownership rule, requires that you submit this information on beneficial owners, right? If you're subject to the law, and we'll talk about that in a second, you've got to submit that to FinCEN, okay? And you have to do it electronically. So what information?
If I could jump in with a quick question, and just watching the clock too, we got to keep an eye on that. The Corporate Transparency Act, one of the other things that it did is it seemed to have expanded the definition of a beneficial owner. So how does that affect how we look at due diligence from this point forward?
Sure. So it's such a great question, and we won't have too much time to discuss it, but I will say this, that under the customer due diligence rule of 2016, the ultimate beneficial owner is defined. It's sort of a two-pronged definition that FinCEN gave us. One is identify individuals with an ownership interest of 25% or greater in a company, and identify one individual with control over that company. So if you were complying with the original due diligence rule, right, you would identify only one member in the C-suite that has some control over the company. Fast forward and look at the beneficial ownership definition under the Corporate Transparency Act, and they say that you must, again, it's two-pronged, identify individuals with an ownership stake in your company of 25% or greater. And then in addition to that, they say identify everyone, any person who has control, a management function. So now you're going to be identifying more individuals in that C-suite who have significant control. So that's kind of the one key difference. The other, in terms of how beneficial ownership is defined, just know that you're going to be submitting more data on your C-suite. It's just a bigger group of people included there. The other main difference, and I've said this, is that under your CDD rule, your customer due diligence rule, you're going to be reporting on behalf of your customers. That's the beneficial owners that you're identifying, whereas under the Corporate Transparency Act, you're going to be submitting this information for your own company and group of companies. Those are the major differences. Does that answer your question, Jeff?
Thank you.
Sure. I'm just going to ask to look at my last and final slide. I'm going to turn it over to Dave because I think, David, because we're short on time, I'll just say that the last functional regulator that I wanted to mention is the Securities and Exchange Commission and the U.S. Department of Justice. These agencies share concurrent jurisdiction over enforcement of our anti-bribery laws and regulations. In the U.S., it would be the U.S. Foreign Corrupt Practices Act, which prohibits companies from providing bribes to public officers, foreign government officials in other countries in exchange for a business advantage. And so be aware of this as well. And when we talk about due diligence, actually, I have I lied. This isn't my last slide. If we can just fast forward to the next slide. To summarize the risks, and then we'll talk about compliance. From everything I've mentioned so far, the largest risks we face in this space in terms of non-compliance are risks posed by third-party intermediaries or gifts that we give to customers, especially where those customers might be owned by politically exposed persons, because those risks, those gifts can be perceived as inappropriate, improper inducements to award business. We face risks under economic sanctions in doing business with blacklisted or restricted persons. And we also face the risk of engaging in forms of money laundering when we collect funds from our customers. But the good news to all of this is that a robust compliance program is a mitigating factor. And regulators have to look at that. It's codified in the sentencing guidelines that they're going to look to see what we've done to achieve compliance. And they take that into account when they're determining whether or not to bring an enforcement action or how much your penalty is going to be. Next slide. My final point really in all of this is that, some of the best due diligence practices is to take into account all these different functional regulators and put it all together and conduct your due diligence and KYC, know your customer, conduct it with all of these building blocks in mind. So for example, what all these different regulatory schemes have in common is they require some of the basic, some of the same information. For example, find out who your counterparties are, verify their identities of all the ultimate beneficial owners with an interest of 25% or greater. It's going to help you comply with FinCEN regulations, but it's also going to help you comply with OFAC regulations. Other building blocks include watch list screening, right? You're going to want to check against the OFAC SDN list to comply with OFAC sanctions. You're going to want to identify your politically exposed persons and your state-owned enterprises. It's going to help you when you're looking at FCPA risks to see if whether or not there's a PEP involved in your transaction. But it's also going to help you with sources of wealth questions when you're trying to understand whether or not you have a FinCEN problem, whether you have a money laundering problem, right? You want to verify where are these politically exposed persons getting their funds from. So when you put all these together, enhanced due diligence, regulators want to see that you're not treating all of your customers the same, but that you're taking more enhanced measures when they're warranted. And we've seen that codified, practically in all the different regulatory schemes that we're talking about today. I think that concludes my summary of the functional agencies, and I'm going to turn it over to David, unless Jeff or anyone else has a question.
Go ahead, David. Thanks.
Thank you, Laura, and thank you, Jeff, and thank you, NAFA, and Jeff, particularly TVBX, for sponsoring this. So I've got about 20 minutes and several slides here. I did see the attendee list before we started, so I know a lot of you folks already know about this stuff, but I suspect there might be some stuff in here that you don't know about. So if you're starting to doze off, time to wake up, or at least try not to be complacent, because there are some new things, a lot of new stuff that I heard that Laura had to mention. And what I'm going to do with my 20 minutes or so is to go through typically what I do when I see a deal come in and look at the various due diligence things or all due diligence concerns, and also look at some of the things that clients have mentioned to me over the last couple months. And so the first one, when I get a new transaction, is look at the basics, the FAA and due diligence stuff. You're dealing typically with an aircraft transaction. And the very basics of, let's see who really owns this plane. Let's see if this plane has been operating been operating illegally. If this plane really is on a 135. All of these things you can find, it's free on the FAA and DOT website. And so the first step of my due diligence process is the FAA and DOT due diligence. So I look at basically the registration requirements to see who's going to own the aircraft if I'm on the buy side, and look at the applicability of the buyers. It's a foreign transaction, a cross-border transaction. Do title searches, rely on the title companies for that. Look at any title blemishes. Actually read the reports and don't get gotchas the day or two before closing. Look at the airworthiness restrictions, requirements to see if there are any airworthiness issues with respect to the C of A. And then look at the cross-border aspects of the deal, whether or not there are issues associated with the import or export requirements. Look at the operational control. If you're a financial institution and you have a client that says, hey, I'm going to operate, Part 91, well, you need to know what the difference is between 135 and 91, or even 125 for larger aircraft. Ask yourself those questions and take a look at them. And more recently, take a look at the truth of leasing. It's really a big deal here in the States for illegal charters. And so take a look and see what the definition of illegal charter is, or I should say the definition, but what is a legal charter? There's some outstanding guidance on the FAA website that has that information. And then from a DOT perspective, look and see if common carriage, if they're holding out, do internet searches of the entities involved to see if there's any type of bizarre operation of this aircraft. Plane spotters is actually an interesting tool to use sometimes for identifying concerns associated with aircraft operations. Again, from a financial perspective, financial institution perspective, but also from just a client perspective. So let's see here. Moving to the next slide. So the topic of the day or the moment, Russian sanctions. And we see this quite a bit. Very aggressive. The various law enforcement agencies are very aggressive with Russian sanctions. You see a lot in the context of BIS. I won't get into what Laura mentioned about OFAC, but particularly for BIS, and that's the one that you will deal with more often than not. And what you're seeing now, once we've gotten past a lot of the initial shock from the March timeframe of 2022, is figuring out what happened between then and now and how to deal with the issues. I literally just received a warning letter from BIS closing out a flight that occurred immediately after March 4th, 2022 for a foreign operator. And so they're realizing that there are issues, but what I think is triggering a lot of this is the OEMs and the suppliers are realizing that these aircraft have potentially operated illegally, and they're denying coverage. And we'll get to that in a little bit later. One of the things you typically see, or I've seen, is foreign operators asking me, hey, can I operate to Russia? Well, if the circumstances are right, yeah, there is an exemption. It's commonly referred to as a temporary sojourn. And unless, of course, and I'll read it here, owned or the aircraft is registered and owned or controlled by, or charter or leased by a Russian or Russian national or Belarus. What's interesting about that, and again, you have to use your common sense, a lot of these things, you just have to ask the tough questions. And so I had a situation where a client said, look, I want to operate this aircraft, and the gentleman's a Russian national. I said, well, you can't. That's an easy one, folks. You can't do it. You can't charter a plane to Russia if you're a Russian national. And then a day later, he came back, well, my wife's actually going to charter it. She's a U.S. citizen. That's what I would consider blatant circumvention of the regulations. You know what's going to happen. So in those situations, you just have to use your common sense and provide advice as best you can. But you hear a lot of folks trying to comply with this temporary sojourn. And so on the next slide, there's the criteria. So when you say, oh, I'm going to do a temporary sojourn, I go, oh, really? So what are the restrictions? And then you get the blank stare. So at the end of the day, these are the requirements directly from the guidance, the BIS guidance, the EAR, export administrative regulations, that discuss the various requirements for a temporary sojourn. And one of the big ones I think most people don't read, it's actually a note at the bottom. It says, and the aircraft cannot remain in country more than 7 days. So in order, if someone says temporary sojourn, my immediate response is, have you complied with the criteria? They're typically going to say, what criteria? And then we go through all of this. So it's something that you have to consider when you're dealing with a temporary sojourn flight to Russia. You see a lot from, I see a lot of flights from Africa going into Russia, other places that still are doing business with Russians in various ways. Next slide, please. So, again, here's the, and I focus on this one because I see this a lot. I'll get to the example. For example, if a Boeing 737 is chartered by a Brazilian national, flies from Cape Town to Moscow, as long as the aircraft doesn't stay longer than 7 days, it should meet the terms of the AVS, or the temporary sojourn exception. Again, if it complies with all the requirements on the previous page. A lot of thought required before you sign off on this, but it's something to consider. Again, this slide's here, and these slides will be out for a while. So the folks that don't deal with this, I know there are a lot on this call that do, but the folks that don't deal with this, take a look at these slides, take a look at the sections, and consider it very carefully if you're going to sign off on any of these flights to Russia under this exception. Next slide, please. When I said OEM supplier support, so here's the funny thing that a lot of aircraft operators or owners perhaps don't realize. The OEMs and suppliers have a lot of data, and they track where aircraft are for various reasons, in large part to make sure that they're for maintenance reasons. But what I'm seeing more and more of is manufacturer, they're terminating, and suppliers for suspected violations. So BAS may not know about it, but they know that these aircraft are operating in Russia, and they're and they think it's a very suspicious operation, and they'll just deny service. They'll typically hire, and the client will then hire an attorney to discuss it with the supplier, and the supplier will tell you that, hey, we think they're flying to Russia in violation of the law. Oh, really? So then you go back and talk to them. There's a whole process here. None of this stuff should be a surprise, but the fact of the matter is, OEMs and suppliers have a lot more data. They're denying coverage. And in fact, a lot of disgruntled employees are also telling on aircraft operators and charter operators all over the world if they think that these regulations are being violated. I've had people request, hey, I want you to submit or request a no license required letter, basically asking BIS to say, look, is a license required? If they say no license required, they're asking for that. If you do indeed find that there has been a violation, you do a voluntary disclosure, and best case scenario, you'll get a warning letter. But that's not that's not necessarily a good fix. If you attempt to do it again, you won't get a second bite at the apple. Alternatively, you can seek a license. There have been various instances where folks have received licenses to maintain aircraft, to receive payments to Russian entities recently. So also try the license scenario. These are difficult cases because of disclosure concerns, and clients are sometimes suspicious. Why should I discuss my operations with my supplier? The supplier's perspective is, look, you don't have to do any of us. We're just not going to provide support. Sooner or later, that plane's going to be grounded. Next slide, please. So here are some of the red flags. A lot of this stuff I hope is common sense, but it may not be. These are all directly from modified from the BIS website. And, is the customer familiar with the operations? Or if they have names similar to on the denied persons, or the entity list for that matter, is the customer or the broker reluctant to provide any information about the end use? And that was that's a classic example of, there's a recent case back from May 16th of last year, two Russian individuals. I'm looking at the press release now, Oleg and Vasily. Not necessarily red flag names alone, but Oleg and Vasily got caught trying to ship aircraft parts. They're based in Florida. They're based in Miami. They were transshipping parts through the Maldives to Turkey, and ultimately the parts were destined to Russia. Well, they got caught. And they got caught by the Disruptive Technology Strike Force. So the government is very aggressive in tracking down these parts and suspicious activities. So, it's something that is happening. And all folks have to do if you're involved in these transactions is look and see if these make sense. And so end use is another one. If the aircraft does not fit into the buyer's intended use, or the part for that matter, what are they using it for? Just ask the questions. Just because the money is incredible doesn't necessarily, it should be a red flag. Paying cash. I don't think I've ever seen a deal recently with cash. Forgive me, one deal in the last year. Watch out for that. And that took a lot of due diligence and a long time before we could get comfortable. Ask if the customer has little or no business background. If they're buying a plane or a part for something that just doesn't make sense, or you just ask the question why. And then unfamiliarity. Again, parts, aircraft, they ought to have a familiarity, they ought to have a background. Why are they going to use it? Next slide, please. Other red flags. If they don't know what they're doing and why they're using that parts, if the delivery dates are vague, if the deliveries are planned for transshipments, if there's intermediaries, if there's any type of evasiveness when you're asking these questions, when you're doing due diligence in the contracts, when you're negotiating these contracts and say, oh no, we can't do that, be very concerned. Unwilling to sign a end user certificate, that's a done deal for me. If the other side's unwilling to sign an end user certificate, I just tell the client to walk away. Too many red flags. That's a big one. Does the deal make sense? Ask yourself. These should be things that we all ask ourselves when we're involved in such transactions. Next slide, please. If there are red flags, talk about it. Don't just, it's good to get other people involved and ask questions within your organization or other entities. Ask outside counsel, ask consultants. The worst thing you could do is just think, oh, I got this, I'm not worried about it. Then if something does go wrong, it's absolutely going to fall back on you, and you're going to look like an idiot because they're going to say, well, why didn't you ask somebody? Why didn't you research this? This is the whole purpose of a red flag. If there are red flags, you can rely on the customer's statements. If that's a BIS policy, you can rely on their statements, provided you've researched there's some red flags, but you make sure there's something in the documents. But if you do see a red flag, you have an obligation, affirmative obligation, to research it. And this is a good one too. Don't self-blind. So we all, go on these conferences and hang out at the pubs or what have you, and you hear something that just didn't sound right. Like, oh my goodness, we're going to Russia next week, and I'm just a little worried. You can't not forget what you heard. Or if you hear something in the agency and think, I think that seems a bit odd, but don't look at it. That's called self-blinding, and that's an enough self-violation. You can't, shouldn't say not a violation. You can't self-blind. You have an obligation to take steps, and you can't not hear bad facts if you know of them. Next slide, please. So if there are red flags, you got to evaluate them. Ask yourself what's going on and why. You know what? Walk away. Refrain from the transaction. You can disclose it to BIS and ask for a determination and wait and see what happens. But there's nothing worse than pursuing something with knowledge and then being alleged that you have specific intent to do something. Again, there's no intent requirement here, but the fact of the matter is it's an aggravating circumstances if you knew about it and proceeded with the transaction anyway. Next slide, please. So moving on to customs exports. So that was a big issue about 2 years ago when in the context of trust. And so there are two basic types of trust. Two basic types of exports: permanent exports and temporary exports. And the NBA and NATA and a various other a bunch of groups got together, and NBA published a great guide out there about this process. We have a link to it. Most of these things are permanent exports. Let me stress, the big thing to consider is that an export or a customs export is completely different than an export C of A or an FAA export. And in fact, you can stay on the U.S. registry, the N registry, and still have to perform an export. This is a very complex and dense area of the law that I think it's something that if you're involved in this, seek a professional, seek an export, retain a customs broker. They deal with this all the time. There are a lot of great customs brokers out there. It'll make your life a lot easier, a lot less worries when, hopefully you'll never get a call from BIS or someone else saying, hey, we have some concerns about these exports you did. So you're going to hear terms like electronic export information. With every deal and you sense an export, ask for any EEI or proof of a filing. And that's important to remember. The text there is the actual terminology and what's required. But if you do any exports, make sure you ask yourself, if this plane is going to stay outside the United States for 12 months, then you're probably going to have to get a permanent export. Next slide, please. Again, 3 primary regulatory agencies involved in the process: U.S. Customs Border Protection, the Census Bureau, and BIS. Best case scenario, you'll do what you're supposed to. You hire a customs broker. You'll do due diligence. Make sure if it's an export, you get an end user certificate if that's an issue. But make sure you understand that all 3 of those agencies could have a dog in this fight if something goes wrong. Next slide, please. So there's some terminology. These are the things that if you're doing an export, customs export, you should understand what these terms mean and how each specific person or entity is involved in the process. If you're hearing about these terms for the first time, not necessarily a good thing. So look at the guidance, talk to a customs broker, and understand what each person's role is in this process. Next slide, please. Again, more on the customs export. A lot of information here because there's a lot of information you have to do if you're involved in the process. So read through these afterwards or get a copy of these slides because this process is something that a lot of people have lost sleep over the last 2 years trying to resolve these issues that a lot of people in the industry were not complying with in the past. Next slide, please. And this is more customs export stuff. The key thing to remember is you have the U.S. principal party of interest, typically the seller, but it could be when you're doing a transaction, if the foreign buyer is here in the United States, typically that person will be the person responsible for filing the EEI. The EEI is basically a hot potato. No one really wants to have that responsibility. But at the end of the day, someone has to do it and make sure your agreements expressly provide someone is going to be responsible for this. Because if you assume it's going to be the other person, chances are you may be wrong. Next slide, please. And the last slide, I believe, is ITAR. I don't deal with ITAR that much. And so ITAR is the International Traffic in Arms Regulations. You see it typically in aircraft have been former military aircraft or been demilitarized. The last time I dealt with this was last year when we were buying 3 Chinook helicopters, former big helicopters with 2 rotors on the front and back. And we did, verify that it had an ITAR certificate in it. You see it with helicopters, aircraft, training aircraft. You see a lot of foreign countries selling their trainer aircraft off or trailing aircraft to convert them into trainers. That's a common thing. And so if you deal with ex-military aircraft, you have to deal with this agency called, or the ITAR and the State Department. It's the Directorate of Defense Trade Controls. So things to look out with respect to ITAR compliance. Here's the top 6 violations. Just basically a large part is just registration, making sure the aircraft or the components are demilitarized. People make mistakes because they just don't have the technical licenses. They have incorrect documentation. They're not vetting the other parties correctly. Maybe some uncontrolled technical data. And just last but not least, just willfully failure to comply. The deal's too good. Next slide, please. And then lastly, risk mitigation. First and foremost, know the regulations and the law. Perform comprehensive due diligence on the client and the transaction. Have a compliance program. With OFAC, every other agency, the first thing they're going to ask, do you have a compliance program? Self-audit. Ask yourself, or have it within the company. Are you doing what you should be doing with respect to the regulations? Stay informed of regulatory and industry developments. Attend these type of webinars. Go to other things that discuss these issues. Be proactive. Take compliance seriously. walk away from bad deals, seek professional advice, consider voluntary disclosures if you find something. And more importantly, I think, don't forget about international sanctions. You could be complying with US law, and the EU has a whole nother set of sanctions, Canada, the UK. So don't forget about international sanctions. Next slide, please. And I think that may be it. That is it for me. We are just at 1 hour. Any questions for any of us, but we sure appreciate the opportunity. Hopefully this will save somebody from getting a call from the disruptive technology strike force. Getting a call from anything called a strike force is never a good thing. That's all I have. And just thank you again, Jeff and Laura, for working with me on this thing.
Thank you, David. Thank you, Laura. I want to invite anybody in the audience who has any questions that for David or Laura or me. Our information is here. Feel free to reach out. Sorry we don't have more time for questions, but we sure appreciate your attending and hope you have a chance to attend future presentations on due diligence. Thank you very much.